today is 255th Friday group meeting. The topic is the Constitution of India and Human Rights. Our speaker is beloved Senior Advocate Mr. Gaurav Bhatia ji, and he was also our Secretary, yes, Supreme Court Bar Association 2016 if I remember correctly. So he addressed our Friday group, our 35th Friday group meeting, that is on 17 September 2016. The topic was the birth. He chosen the birth of collegium. It was available in YouTube. Thank you very much, Bhatia ji. Once again, you are so kind. We are eagerly waiting for your lecture. We are watching you regularly on TV channels and other things. Please, please continue.
So, first of all, a very good afternoon to all my colleagues and fraternity. And also, I would like to say that this is my family, and if you come to your family, it's always a delight and a pleasure. And before I get into the formal topic that we have to discuss, I would first of all say that it's a great achievement for any initiative to reach this far and conduct 255 lectures, study group discussions. It's a testimony of a vision of perseverance, as well as how if one can dream, those dreams can also be turned into reality. And when I was seeing the illustrious list of speakers, I must admit that it included former Chief Justice of India's judges sitting in former senior advocates that we have learned from, and one of them is sitting here blessing us. I must say that it also goes to show the kind of richness that the Supreme Court as an institution and the Supreme Court Bar Association has. And I can proudly say that people talk about giants like Mr. Nariman, Mr. Soli Soradji, Ram Jethmalani ji. We have had the privilege of seeing them in flesh and blood. And it's a great honor for all of us that these people always stood for what today's topic is: the Constitution, the Supreme Court, and human rights. And I must, at the very beginning, compliment. He's a colleague at the bar. He's also a trusted friend, supported me in my journey in the bar, whether it is elections or cases. G.Seshagiri ji is one of those individuals who can light up your life with a smile. He'll wish you, he'll hug you to tell you that he's there. And I must say, with a deep sense of admiration, that I am very proud of you for the fact that you took this initiative, and you were just telling me it took you 7 years or 6.5 years to call me back again. But it also shows how much richness the bar has, that for a speaker to get a chance to be honored to be amongst all the advocates of the fraternity, you have to wait for 6-7 years. So I take it as a compliment for the Friday group that we have. Now, having said this, the topic of today's discussion, I think, is the most important topic that can be discussed. Ultimately, if you look at the history of not just our country, the Constitution of India, but as a whole, the human race, why are we different? We are different because there is a sense of dignity involved. There is a sense of personal liberty involved. And I have this quote from Justice Bhagwati. He very beautifully said, if we want human rights to become meaningful for the large masses of people in the country, this is the only way which it can be done. And what was he referring to? He was referring to a via media created by the Supreme Court called the public interest litigation. Now, how do we trace human rights? How did it start? When was it factored in for an advocate to know that human rights are the real reasons of our existence, our respect, our personal dignity? वो कहते हैं कि आप मेरा सब कुछ ले लो, मेरी इज्जत मुझसे ना लेना. That is what personal liberty, dignity and respect is. So the first was the Magna Carta in 1215 AD, when the Englishmen, they decided to ensure that the common people, the rights that they have, is formalized and every person can come forward and his rights can be preserved. It wasn't at the mercy of the ruler, it was non-negotiable. Following that, in the US, which is one of the oldest democracy formally, we are the largest. Some people say unofficially we are also the oldest. But US has a Bill of Rights. In 1791, the rights were crystallized, and like we had certain malpractices even in the US. I stayed there for 5 years. I studied there as well. I can tell you that there were certain malpractices there as well. On the basis of color, they discriminated. Even on the basis of gender, they discriminated. And when our democracy came into existence through the Constitution of India, there was no gender discrimination. But in a country like the US, the gender discrimination was there and the female gender was not allowed to vote. And then the evolution was such that worldwide, after the Magna Carta and the Bill of Rights, worldwide, the formation of United Nations happened. And that is why I say that the concept of personal dignity, human rights, self-respect, this is universal in nature. It has no geographical boundaries. And we saw that the United Nations, they adopted the Universal Declaration of Human Rights. And once this was adopted, then it became a guiding force for all countries to follow. Because as we all know, that including India, all countries are signatory to the Charter. And thus, there were certain basic rules, principles that were set in, and those had to be followed by all. And this was the beginning when very famously it was said there, human rights form the moral and the legal backbone of any democratic society. And I think nobody would disagree with that line. Now, we all know about the freedom struggle. What was the freedom struggle all about? The freedom struggle was all about liberty, about human rights, about being treated equally. If an individual has the potential, the person should have the right platform to rise to the highest level. But what the Britishers did was that on the basis of the place of birth, the class, and they were oppressing us. So thus, individuals with very high caliber were not allowed to enter public spaces. India, with its indomitable spirit, decided that ultimately this has to come to an end. And freedom fighters like Mahatma Gandhi ji, Sardar Patel ji, Netaji Subhash Chandra Bose ji, Jawaharlal Nehru ji and many others, we attained freedom. Freedom from oppression. And then came the Herculean task. It's very easy. The Herculean task was definitely to ensure we get freedom. But freedom for a person who has not been free for so long, how do you channelize that vision, that energy into something constructive? That was the daunting task that Indians as a nation had, and the Britishers infamously said that we are leaving. Very soon these people will realize that they are not meant to govern. They are meant to be ruled by us. They thought that with the kind of rich diversity that we have, individuals will fight amongst themselves. There were different religions. There were different castes. There was this gender disparity. Plus, a lot of regional aspects to the identity of an individual. And I must say this, that I have earlier also said it in the bar. The Supreme Court bar again is a reflection of how various positives from all across India gather here. You know, I know individuals like, if we have Nariman ji from Mumbai, we have Rakesh Dwivedi ji from Allahabad High Court. We have P.P. Rao sir from the south. We have K.K. Venugopal ji. Similarly, all parts of India, we have the best talent coming to the Supreme Court. And when we merge here, people, when I was contesting an election, people said that आप इस स्टेट से आते हैं, वोट बहुत हैं इस स्टेट के. मैंने कहा, I'll never ridicule my bar. There is only one identity we have, and that is of the Supreme Court Bar Association. And we are grateful that we have giants coming from various parts of the country. So, why did I cite this example? Because similar, in a larger way, India also has so much of beauty, so much of talent, and people coming from all across the country, even for freedom struggle, and now the daunting task of having a constitution itself. So when I was going through various speeches in the Constituent Assembly for today's discussion, I like to speak extempore, but I have made some points so that I can also, be close to the topic that we are discussing. Dr. B.R. Ambedkar ji is definitely an idol for all of us. He is a man who has given us the Constitution, very, very good, very admirable. But at the same time, if you look at the background from which he came, not privileged at all, total hardship, nothing to eat, no money to even pay the academic fees. He rose to the level that he beat every giant intellectually, and then he gave us the Constitution. So when they were discussing human rights, fundamental rights, he said a very beautiful quote which I want to place for everyone's consideration. This is 9th of December 1948, and just the way human rights are the soul for every individual's existence, Dr. Ambedkar felt that Article 32, which is very relevant to all the Supreme Court lawyers, is the soul of the Constitution. So he said, and I quote, "If I was asked to name any particular article in this Constitution as the most important, an article without which this Constitution would be a nullity, I could not refer to any other article except this one. It is the very soul of the Constitution and the very heart of it, and I'm glad that the House has realized its importance." Article 32. And the last speech that he gave in the Constituent Assembly, what he said is very relevant for all budding lawyers, for every citizen. Sometimes we say that the problem is with this system. This is not good. Some AORs here will also share. I've been an AOR myself. Filing is a big problem. Listing is a problem. Yes, there are problems. But it is important that we apply this to the problem and then see how we can work around the problem. Because systems, especially the Supreme Court of India, has to work. And not only work, it has to work well. You are the last hope for more than 1 billion people. They look up at you They feel that you will be the torch bearer of getting justice for them. So he said this: however good a constitution may be, it is sure to turn out bad, because those who are called to work it happen to be a bad lot. However bad a constitution might be, it would turn out to be a good one, because who are called to work it happen to be a good lot. So I think it equally applies to all of us, that every system has its shortcomings, there are issues, there are problems. But if a constitution can work for a country like India, just because of the good people that man institutions, be it the executive, the judiciary or the parliament, and at the state level also, I would say that Supreme Court definitely, with the Bar Association contributing with its rich color, will do well, and it has a very bright future. That is one thing I am sure about. Now, one very fundamental thing that we need to understand, it is said that human rights, fundamental rights. A lot of people will always ask, how do we distinguish between the two, and what is the similarity between the two? So, as I said, with human rights, there is a term always used, which is inalienable rights. These rights are not bestowed upon an individual because of a written constitution or because there is a common law country and it is being passed on, or a monarchist says that you have this right. These are rights you are born with. The moment you cry for the first time, you are hugged by your mother, you get the right. The right to exist with decency, dignity again. And to a different extent but overlapping with human rights is fundamental rights. Fundamental rights now are enshrined in the Constitution in Part 3. The human rights cannot be taken away by any amendment. But we are all aware that from Article 19 to many other articles in the Fundamental Right chapter, those have been amended. Those have been curtailed, subject to reasonable restriction as well. So therefore, the moot difference first of all would be, inalienable rights cannot be taken away by an amendment, whereas fundamental rights for larger aspects, many fundamental rights we know are subject to public order, morality, decency. If it is required in the interest of the nation, they cannot be an absolute fundamental right. And thus those are curtailed. So when we come to Part 3, the broad fundamental rights are divided into 6 categories. Right to equality, right to freedom of speech and expression, which we love to use as lawyers, and if somebody tries to curtail, we are furious. Right against exploitation, prohibits human trafficking, forced labor, child labor. Right to freedom of religion, very, very important. It can be a topic of another day's discussion without me, so that there is no controversy. But how far can we take the right to religion? Right to religion with right to equality for a gender. We need to understand that. So this is a very important aspect, and I think even with our differences, lawyers can come together. We can have different point of views, give very formidable arguments, heated ones too, and then after the lecture is over, we can have a cup of tea together. That is the beauty of having a dialogue, and only lawyers can do it. I will end the lecture with a very beautiful quote which I have saved for the last. But these thoughts are coming to my mind, so I am also drifting to some other aspects which are very relevant. Not just about human rights, about our coexistence. We are all foot soldiers of Constitution. And I am sure that we can lay down our lives to protect the principles of the Constitution. Only a lawyer can do it the most. And therefore I come to this. Next is cultural and educational rights. Again, it is a topic that is being discussed right now with great fervor. This again, such gatherings will make our life easier and nectar would come out. The poison has to be eliminated. And last but not the least, the right to constitutional remedies, Article 32, that I already mentioned. Now, the next topic in this issue would be, what is the role of the Honorable Supreme Court? How has it protected the Constitution and taken forward the principle of human right? Self-evolution also at times. Many things not written in the Constitution explicitly followed by the Supreme Court. So the Supreme Court, when it comes to human rights, has been a great contributor to three things. Equal protection for every person from arbitrary action. There has to be a prescribed procedure, and irrespective of who you are, that procedure will be followed. And that is the equality clause that is also part of the Constitution. Second, procedural due process. If a thing, we have seen preventive detention cases also, which is again very relevant to human rights, where how the law has evolved over the last 7 decades. And this Honorable Supreme Court as well as the High Courts of the states in many cases have said that yes, fine, you can detain a person, there can be preventive detention, but there is a procedure in place. The person needs to know well within a stipulated time, which has been changed at different years, that this is the reason why you are detained, and he is also entitled to a fair hearing by the board. And third, also very actively in the environment protection area. So while I am addressing this, what are the tools that have been evolved by the Honorable Supreme Court, and we all have benefited, we have participated, and we have seen these tools being used very effectively, especially in the Supreme Court. It makes us very proud. First is, as I said, public interest litigation. Now, Justice Bhagwati and Justice Krishna Iyer, they are known to be the founding fathers of this concept of public interest litigation. And when it was started, it also received a lot of criticism. Criticism because there has to be a fine balance between judicial activism and judicial restraint. So people felt that why is the court meddling into the affairs of the parliament and the executive? But the Supreme Court, in many cases like T.N. Godavarman, M.C. Mehta, and there are many others as well, very clearly said that if there is a vacuum and that results in infringement of a fundamental right or a human right of a person, the executive and the legislature, if they are not doing their job which they are expected to do, the Supreme Court would definitely step in. And this is not judicial activism. This is the duty of the Supreme Court and the High Court, being courts of record, to ensure that no violation of such sort takes place. Now, we are all aware, some examples would be Husainara Khatun case, where the right to speedy trial was recognized, and the plight of under trial prisoners, when it was brought to the notice of the Supreme Court intervened. Just a thought of reflection. This happened in 1979. So 46 years. We ask ourselves as lawyers, it is definitely a step in the right direction. But what is the plight of the under trials today? You would be aware, because you are all very aware individuals, that even today in the prisons, when we read, more than 2/3 of the inmates are actually under trial. 2/3. So the very concept was that if you are behind bars, there is a delay in trial. Sometimes it was noticed that the maximum sentence for which a person was charged is over. Say the offense prescribes sentence for 3 years. The person has stayed behind bars for 5 years. If he is acquitted, you can't return those 5 years. If he is convicted, he is to get 3 years of sentence, but he is still behind bars. And the same is happening even till today. So when we discuss this topic of human rights, first and foremost, as a well-wisher, as a guardian, as a brother, whatever you may take me to be, I would say the spirit of reaching out to these people, because ultimately it doesn't matter we are a Supreme Court lawyer, we are a High Court lawyer, or we are a trial court lawyer. The one identity that keeps us together is the black coat and the band. Our duty is towards individuals. And sometimes satisfaction and pride is far more valuable than the money we make. So we need to reach out to people to ensure that if there are such individuals, there should be a mechanism that we can address their issues. Similarly, there was Bandhua Mukti Morcha case, 1984, exploitation of bonded labor. I've already mentioned the MC Mehta case. The second was the epistolary jurisdiction. Now, this I think again shows the true character and depth of the Supreme Court. How? I don't include the registry in this. When we file a petition, sometimes they will say, line में space कम है, clear नहीं है, page बदलिए. They should go through the guidelines made by the Supreme Court in entertaining petitions. A postcard with illegible handwriting, a letter directly to the Chief Justice of India, being entertained by them. And why was it done? Because the Honorable Supreme Court of India, manned by people, the judges of great character, vision and commitment towards our democracy, they felt that procedure is not important. It's only a means to achieving the net result of delivering justice, of imparting justice. And thus they said, postcard भी आएगा, चिट्ठी भी आएगी, तो हम सुनेंगे. It was converted into formal petitions. Letters were converted into formal petitions. So the first tool I told you was PIL. Now postcard letter petitions is the second tool that was created. The third, which is very prevalent in the Supreme Court and rightly so, is the suo motu proceedings. Now, two experiences, when I come to suo motu, I will tell you, in the last 2 decades that I have had the honor of serving this bar and the Honorable Supreme Court of India. One was when I was the Additional Advocate General of the state of Uttar Pradesh. I received a message from the court of the Honorable Chief Justice of India. Honorable Justice Kabir was the then Chief Justice of India, a wonderful judge, even a better human being. In a newspaper, he read an article that in Bulandshahr, a minor allegedly was raped. And when the family went to lodge a complaint, the minor was put behind bars in the lockup in the police station. So he was very disturbed. And he knew me well, he knew I'm serving the state, so the board flashed a message under my name that please be present. So I reached there. He showed me the news, he asked me. Now, I didn't have any instruction, but it was my duty to assist the court. So I said it can be listed the very next day or in a short while, and I'll assist the court. Then the matter came up. I will tell you honestly, I am duty bound to serve the state of which I am a legal officer of. But my duty is also towards the court. So I spoke to people heading the government and I told them that this is unacceptable. And this is a case which I would love to lose in the sense of defending my state. And then I went to the court. I made a statement that yes, there has been a lapse on part of the state government, and no amount of compensation can bring back the dignity or the trauma of the girl. But we will ensure that such a incident doesn't happen in the future. The court, they noted the submissions made, and we were able to immediately ensure the release of the young girl. And it goes a long way to show how, one, the court was vigilant. They have 60 matters to read every day on a miscellaneous day. And definitely they work very hard, if not harder than the lawyers, but equally hard. At the same time, they were alert to such a report of a newspaper because it involved the violation of human right and fundamental right. It inspires confidence of a lawyer and a citizen. And second, as I said, that as lawyers, yes, we have a duty towards the client, but not at the cost of somebody losing their dignity, their right, which is guaranteed to them, and more so on the state side. State practice, you are never an adversary. You are always assisting the court. And I must tell you, the second incident again, it is close to my heart. One thing that I can give my life for, and I'm sure all of you can, is the band that we wear. So, just last year, there was a case where I was specially requested by somebody very close to me to appear in a district court for a very heinous crime that was committed. So I decided to appear. Now, first day I appeared, second day I appeared. The moment I entered on the third day or the fourth day, there was a crowd of lawyers. They came inside shouting slogans, and the district judge was sitting there on the dais. And they immediately said, no work today, no work today. So they are also part of our fraternity. Out of respect, I come from a legal background. I told them that your request has to be honored. No problem. I'll take an adjournment. And my junior who was sitting here was also with me in the court. After that, the case, the judge asked me what date. I said any date that is convenient to all, and we got a date. These lawyers, I don't think they are lawyers because they were not wearing their bands inside the court. And they were shouting slogans in front of the district judge. Third, your own colleague is agreeing to the fact that out of respect, though it is not legal, not permissible as per the Supreme Court judgment, but I will not work as a mark of respect to you. One young fellow comes and he snatched my band. When he snatched my band, as I said, you know, I can give my life for this band. This is what I have. This is what we have earned through our hard work. So I told the district judge that this is unacceptable. The district judge very fairly also stated that yes, action will be taken. But now comes the beautiful part, suo moto. Before the day ended, I got all the details from the district judge, had written a letter to the Honorable Chief Justice of India, and the next day the bar came together we mentioned the matter and the court suo moto said, we are taking cognizance and we will treat this as contempt. So this is the power of the Supreme Court. Suo moto. And now that case is going on, and I must share with all the lawyers here, senior and junior as well. After that case, I got 3 calls from various lawyers. One was a very bright young lady lawyer. She said that on the very same day I had also gone there. I was pushed by colleagues and I was asked not to work. So we ensured that in this case, that incident is also added. Then there were 2 other lawyers who said that when we go there, the other lawyers say, "Ye bahar wale kaise aa gaye? How can we be outsiders in a courtroom?" It's a serious point to dwell upon. If not a human right, snatching is definitely a human right because it violates your dignity, but a legal right to practice. So this happened, but it talks greatly about the Supreme Court character and how it comes forward to ensure that these rights are not violated by anybody proactively. Then there is appointing of amicus curiae. Now, people say that amicus curiae when appointed, it's also because of great legal knowledge that one possesses, the confidence the court has in a lawyer. And some amicus curiae when appointed, it's been 2 or 3 decades and they continue as amicus curiae. So you can imagine, some cases are not to be disposed of, not because of amicus curiae or my colleagues at the bar, but because they continue, like T.N. Goda Varman and M.C. Mehta. So this is another tool that the Supreme Court has adopted. Then it is help from NGOs. We all know that there are various renowned NGOs that have been involved for social causes. They also assist the court. And all these examples will make it very clear that there is a lot that has been achieved, but at the same time there is a lot that has to be achieved still. And if a lawyer has to see the glass which is half full or half empty, the lawyer should always see the glass as half empty. We have to work to ensure that rights for everyone are protected. Now, keeping the time in mind, there are a few things that I definitely want to share with you. We all know that NHRC came in only for the very purpose of protecting human rights of individuals. And while preparing for this lecture, there have been some very high points. Like in Amritsar, there was an incident which I wanted to share, where for pickpocketing, 4 women were nabbed by the police and on their forehead a tattoo was inscribed. So imagine for pickpocketing having a permanent tattoo on your head. Now NHRC came forward and it ensured that those people from the police are arrested and disciplinary action is also taken against them. Same is the case in Jammu and Kashmir. Bijbehara massacre happened in October 1993. 37 people were killed by BSF battalion opening fire at them. There were 10,000 people at that time in the ground. And 37 lives lost. NHRC immediately came in and they took it forward. And similarly, what I said for the Supreme Court, the NHRC also, it's easier, it's less formal. If you have dealt with NHRC, that you can write a letter and they entertain it as a complaint and it moves forward. And from my personal experience, I can tell you in cases of a violation of human rights and fundamental rights, NHRC recommends compensation as well, and hundreds of crores in total have been paid to victims whose rights have been violated. So this is again, a statutory body which is very essential. But on the flip side, if we are discussing the positives, we have to also discuss the shortcomings of any institution, though we revere, but we have to. So, even the High Court, many a times have commented that is it a toothless body? Is it time to increase the power of the NHRC? Because sometimes, like in cases I've seen in West Bengal, the first petition that I filed as a lawyer under my own name after 15 years of practice was when 3 people, they were brutally murdered in West Bengal, and in one of the cases, the dead body was seen hanging from an electric pole in the wee hours of the morning, and the police said within 24 hours completing the investigation that this is a case of suicide. So when I read that news, I couldn't control the feeling of moving the Supreme Court, because I am a member of this institution. And the Supreme Court then issued notice. In all 3 they issued, 2 later they said because investigation has gone a long way, we will not interfere. In 1, the matter is still pending. But what is the Human Rights Commission doing? And irrespective of the state, any state, I think if they have a team, they have all the resources, they should ensure that in cases of women being violated, in cases of communal violence, murders, dacoity, before a person can move the Supreme Court or the High Court, it is the NHRC that should walk up to that family to provide solace, succor, to let the citizen know we are there. And I think that would be something wonderful if it can be achieved by the NHRC. And we can raise it on various forums. All of us go for lectures, we speak on various subjects, seminars. We should raise these issues. Status quo is not meant for lawyers. Somebody who's not moving is dead. Just breathing is not enough. It is important that we take actions and we bring about a positive change, and that is the reason of our existence. Now, 2 very important incidents, massacres, pogroms, whatever you wish to call them, I must share with you. How things change when there are individuals who are aware of their own duties. We all talk about rights, we are talking about human rights, but with rights also, we need to know about our duties towards society, and especially the fundamental duties that have been enshrined in the Constitution. So there was 1984 Sikh riots. It put our country to shame, it put secularism to shame, it put law and order, public order, morality to shame. And I've been told by many senior lawyers that during that time, if there was a community that came forward leaving everything, you would be proud to hear it was this Supreme Court Bar Association. I personally heard of Mr. Ram Jethmalani ji and many others stepping out of the court premises, reaching out to the Sikh families and ensuring that they have shelter, they have homemade food, they feel secure, they are not threatened. And there would be many other lawyers. Mr. Ram Jethmalani ji is only one example I am citing. But look at the irony, happened in 1984, justified by those who should have protected the citizens. And imagine if you've lost your loved one. Imagine from a child's point of view, 6-year-old, seeing his father being burned alive. From a husband's point of view, his wife being victimized, violated, and then he's rushing to the police station and no complaint, no FIR being registered. And this, I think, was one of the dark hours of democracy. And how do we redeem ourselves? And that is why law, human rights is very important. 11 Jan 2018, and I was a witness to this. there was a bench headed by Honorable the Chief Justice, Justice Kehar. He happens to be the first Sikh Chief Justice of India, but I don't think that is the essence of this order. He was sitting in the bench with Justice Khanvilkar and Justice Chandrachud in 2018. We are talking about 84. So it is 34 years. 34? Yeah. And then they pass an order in which they say that in respect of 186 cases that are pending investigation for 34 years, we constitute an SIT. And you would be satisfied, if not happy, to know that an SIT was constituted. And people who were earlier ministers in the government, who were members of parliament in the government, are today behind bars. They have been convicted. And salute to the citizens, their spirit. They didn't carry swords. They didn't carry any guns to shoot people they thought were the perpetrators of crime. They waited. Their faith in the rule of law, in the systems that we have. And that is why I think this was a fine hour. If that was the dark hour, this was a fine hour. When now we see after 40 years, people behind bars convicted, their appeal also dismissed, and now one is pending before the Honorable Supreme Court of India. So one is this. Now, second, I am sharing how human rights in the eyes of judges also sometimes are different. I gave you this example. In the second, we all know another dark hour was the Kashmir genocide. When people due to their ethnicity were targeted, their rights violated, and they were asked to leave the valley. Now, this was in 1989-90. 1989 was the start, 90 and then onwards. And it is said that hundreds of thousands of people left the valley. I like participating in discussion, so I had gone for a discussion on after it was during Article 370 abrogation. So I met a person whose father, Mr. Taplu, it is an infamous case, was brutally murdered. His son was there. So in the audience, when he looked at me, and I was told that he is Mr. Taplu's son, so I asked the anchor to wait for a minute. I walked up to him, I hugged him. I hugged him because it came from within. I just wanted to tell him that, you know, the pain, the agony that he has undergone is not his own alone. We are all there for you. So after that, he spoke to me about justice. I said, yes, I can try to help you. And we filed a petition. It is Ashutosh Taplu versus Union of India. This was filed in 2022. So 32 years. But what was the silver lining for me as an advocate? The silver lining was that after 34-35 years, the Honorable Supreme Court in the case of 1984 riots had constituted an SIT. So I thought maybe if I am able to convince the court will also order an SIT in this matter, especially because the FIRs were registered. But what happened in the investigation, a final report or a charge sheet was also not told to these people, and this was only one example. So I argued the matter before a bench I wouldn't name, and you know, very generally we are trained to control our emotions and passion. But that day, because I had met the individual, I had read so much about the Kashmir genocide, it was a very passionate exchange of ideas and my arguments. Ultimately, I am sorry to say that I could not convince the bench. The result is that, as I told you, that after this petition was dismissed, the judgments of conviction came in the 84 riots matter. So as a lawyer, I've always felt that what would the destiny of these people would be if the Honorable Supreme Court had, maybe if my arguments were not so convincing, on its own entertained the matter. there would be thousands of families who would have been balmed by the order, and maybe they would have got justice. So this is another aspect that I wanted to bring out in front of you, that two massacres, two pogroms, and different fate, because the Honorable Supreme Court felt differently, the judges felt differently. And nothing against them. I'm sure that, from their wisdom and experience, they thought that this should be the fate. And sometimes I feel, be it a politician or a judge, you also think about the ramifications of your order. You feel that, say, something that is now a thing of the past, if opened, what would it result into? And I think I tell myself this every time, that this would be the reason that the honorable judges, and I respect them deeply, did not entertain this petition. Now, after this, I just want to touch upon one or two things more, and then I am aware that time is of the essence, but I don't want to miss out on anything which is very important. So there are very important aspects of human rights, and if we don't refer to the Keshwanand Bharti case, I think we would be not doing justice to this lecture. And the numbers, I think lucky are the lawyers who have witnessed the arguments during that case of Keshwanand Bharti. And as I said just now, the basic structure doctrine came in, yes, definitely by a pronouncement of 13 judges, 7/6 judgment, saying that basic structure of the constitution cannot be altered. But what caught my eye when I was reading was the fact that people say the best ever lawyer we have seen, arguably or non-arguably, depending on how you judge, is Nani Palkiwala. So there are other people who would say, no, H.M. Sirvai ji was, if not better, equally good. So interesting it is that Nani Palkiwala ji was appearing for the petitioners, and mind you that Attorney General for India, representing the union, has the right to audience in any court. But such was the sheer brilliance of H.M. Sirvai ji that he was, as the Advocate General of Maharashtra then, representing the state, and he opened the arguments. And the hearing went on for 68 days. 68 days, and out of that, I think, if I can capture the number well, H.M. Sirvai ji argued for around 21 days in a go. And I'm sure that Nani Palkiwala ji also would have argued for around 23, 24 days. So imagine the kind of intellect, the jurisprudential qualities these people had, not written in the constitution, but the nation needs to find a solution of the problem that we are facing. And what was the problem, if I may summarize? For the want of time, I will just put it in a nutshell. And this is the question that comes to my mind also very often. One, if the judiciary, the parliament and the executive are creatures of the constitution, and it is said the constitution is supreme, and then Article 368 gives the parliament the power to amend the constitution, can you amend it in a way to take away the very constitution which gives you the power? And it was said that yes, you can't have a restrictive interpretation to it, and it has to be expansive, and thus the amendment can be made by the parliament. And at that time, the sheer brilliance of Nani Palkiwala ji, I was reading about it that when he agreed to appear in the matter, there was a very bright team of more than 20 lawyers who used to assist him. But he used to be locked in a room just reflecting upon the problem and how to find a solution. And then came the basic structure theory. And to the extent I had brought those paragraphs because I really found them to be very interesting, intriguing. I'll share with Seshuji, maybe he can share with all of you. But the brilliant part was that he said no. If you have the power, you can't turn a democracy into a monarchy. You can't take away the human rights, which are again inalienable. The fundamental rights can be curtailed but not taken away. And the best part was essential features of the basic structure. He said the supremacy of the constitution, the sovereignty of India, the integrity of the country and the unity of the nation, which is very relevant today, and the democratic way of life as distinct from mere adult franchising, and the most important, which is relevant to today's lecture, the guarantee of basic human rights elaborated in part 3 of the constitution, and I marked it for all of you. So this was part of the argument put forward. So deep, so incisive, and by 7-6, this theory of basic structure was accepted. And you all know it has stood the test of time. Very recently, the pride of our bar, as well as he's been on the other side, Justice Rohinton Narimanji also, released a new book. It is all about the basic structure doctrine, and I was hearing his lecture online. And again, some very brilliant ideas, and he justified, and he said that this was the right thing to do. And it has protected our democracy. So, now, having said all this, and large portions I have not been able to cover, but I'm sure that I'll not have to wait for 6 years before Seshuji invites me again. I've done my homework well, I can use this homework for the next one also. A very important thing came to my mind. What have we gained from this lecture? This is the part that I wanted to come to. And I would say the first and the foremost thing for me is the fact that I have been able to spend time with all of you. Knowledge, ideas, disagreements, that is all fine. But with my family, Seshuji gave me the opportunity and the privilege to be here, to bring some smiles on the face, to feel that I am not a lone crusader. I have such worthy people who are generals in my army, and we can achieve the world. Second is the fact that I am hoping, in my own humble way, I have been able to ignite a few minds. I have been able to add some fragrance to the soul of this room. That for me, I think, would be very satisfying, and I'm sure that when we are in the company of legal giants who are staring at us right now, I'm nothing, but it is an endeavor to tell them that if they kindled a candle of knowledge, of uprightness, that candle burns bright because of them. So we owe a lot to them, and thank you, Seshuji, for giving me an opportunity to be able to convey this to all of you. Now, third is, I think, the legal part, the judgments, the concepts that we have discussed. The beautiful thing about law is that nothing is final. You reach a place where you feel this destination is beautiful, and you feel it is the destination. And after 20, 30, 40 years, others come and they tell you it is not a destination, it was just a stop. The destination would be even more beautiful. Such is the story of our democracy, as well as the Constitution, which is our holy book, and it will always remain so. And I promised you I will end the lecture with some lines of a person I admire, very beautiful, and they resonate with me always. And once I've quoted them, you will realize that why I say that. So H.M. Sirvai ji had famously said this, and every word is meaningful, and you must, I have it on my computer. So most of the lectures, seminars I go to, I do quote this line. Not because it's easy to be gained, but I think the respect it brings to every individual and the way we should perceive our differences also. So he said, and I quote, I realize that some of my criticisms may be mistaken, but to refuse to criticize judgments for fear of being mistaken is to abandon criticism altogether. If any of my criticisms are found to be correct, please note, if any of my criticisms are found to be correct, the cause is served. And if any are found to be incorrect, the very process of finding out my mistakes must lead to the discovery of the right reasons or better reasons than I have been able to give, and the cause is served just as well. So today also I would say that whether I have been right or wrong, I have shared with you valuable inputs or invaluable inputs. I am sure my presence will definitely inspire you to find better reasons than the one I have given and to prove me wrong, and that would be my biggest victory when I come before you. Now, two more things with Seshuji's permission, very relevant. One is human rights of lawyers, as I see them, and because I am a member of the bar and I breathe bar and law and I know the problems. I've had the honor of serving all of you for 3 years as secretary and joint secretary of the bar. First, I would say my right as a lawyer, and I call it a human right because as a lawyer I also have human rights. The registry of the Supreme Court cannot be autocratic. We have all worked in the High Court. This is my opinion through experience, that the judiciary goes all out to nurture us. But somewhere the registry, and a spade has to be called a spade. At least this is the way I've been brought up. I am not afraid of any individual. The registry needs to change the way of functioning, show more respect to the lawyers. And when I say this, I'll share another example with you. When I was the secretary, it was a day in the month of May, and I get a call from one of my female colleague, and she says, please come to the registry, sir. I said, I'm coming, I'm rushing. So I reached there. What I see is the temperature is 45 degrees. There were 2 counters, 3 counters for filing. Now, lady advocate on records was standing next to a queue of clerks. And I have no problem with that as long as it is dignified. But certain clerks were pushing these lady awards with their elbows. There was no water. The fan was not working. So as secretary, I felt that this is unacceptable. And that is why I said human rights of a lawyer. I immediately called up the Secretary General and I told him that if in the next half an hour we don't have more counters and this queue for the lady lawyers is not moved away from the queue of the clerks, because you can't treat the same both the classes, we will definitely raise it at the highest level. And you would be surprised the power of being fearless and upright, and I'm talking about the bar, not about myself. The very next day in the morning at 10 a.m. there were 2 more queues, 2 more counters only for lady lawyers within 12 hours. So this is the dignity of a lawyer which has to be kept in mind. Yes, we are foot soldiers, but soldiers also deserve respect, and they needed to be treated with respect. Second, this is another thought. He's already given me a tab, so that means I need to end. So I would say that this no Passover business, and also the fact that there is a sequence that will come out in the morning, is just not acceptable. We are human beings. I don't have a computer in my brain that I can rush from one court to the other and then manage my entire cause list and do justice to the clients. We are all here to serve the citizens of the country. We should keep that in mind. And now I would not even come to the third one because Seshu gives me a lovely smile and he says you need to end. So in the end, I just want to thank all of you for being here, being so patient. It has been a wonderful afternoon for me. I will cherish the memories. And एक couplet बोल के मैं अपनी बात खत्म कर देता हूँ. What you all mean to me? गम नहीं अगर बदल जाए ज़माना, मेरी ज़िंदगी है तुमसे कहीं तुम बदल ना जाना. And I would say this is a couplet written by me. तुम हो तो हम हैं, तुम हो तो हम हैं, तुम नहीं तो हम कहाँ रह जाएंगे. परछाई से भी ज़्यादा तुम्हारा साथ निभाएंगे. परछाई तो चली जाती है रोशनी के जाने के साथ, हम तो मर के भी तुम्हारे पास रह जाएंगे. Thank you.
Thank you very much, Gauravji. So nice.
I've exceeded my
No, it's within time.
Yeah.
So that to really enlighten us and inspired us, it ignited us, all of us. Now I request,
Autograph.
Yeah. Rahul Agarwal give a vote of thanks,
Yeah.
I've earned my water now.
Yeah, first of all, I thank G.Seshagiri Rao sir to give me this opportunity. So today our speaker is our Gaurav Bhatia sir, and today he has very beautifully enriched us in the topic of Constitution of India and human rights. Today sir has discussed about the fundamental rights and the human rights, what are the greatest importance in every individual. So sir has also touched the topic that how the PIL has been evolved, what was the importance, and how there were discrimination throughout the globe, and how UN adopted the Declaration of Human Rights, which India is also a signatory to it. How Dr. Ambedkar has said that the Article 30 is the soul of the Constitution. We have the right to exist with decency, rights, and discuss all the rights and fundamental. Sir has also discussed about that we have fundamental duties as well, as discussed in the Constitution. Sir has told that the role of the Supreme Court in preserving the human rights. Sir has told that equal protection to every individual, procedural due process and environmental protection area, the Supreme Court is working. And the tools are the PIL, out of which that the right to speedy trial, under trial condition were discussed. The Supreme Court has the apostolic jurisdiction through which through the postcards and letter received by the Honorable Chief Justice, they have treated the petition. And the suo motu proceeding with the greatest importance. Sir has also discussed about two of his experience. One with the Justice Altamas Kabir. He has in a newspaper article, he has taken the suo motu proceeding for the girl being raped, and that's how. So sir, thank you sir for this beautiful lecture, and we all have been enlightened, sir.
Thank you so much.
Thank you, Rahul. Thank you very much. Thank you, Gauravji. We'll have a cup of tea.
अच्छा ठीक है.